Hello, and welcome to the IMS Insights podcast. I'm your host, Adam Bloomberg. Today, we're speaking with IMS elite expert Gabriele Goldaper about early case strategy, expert reports, trial testimony, and intellectual property disputes. She will also give us her insights on apparel industry trends and advice for future experts. Gabriele is a product authentication expert with more than 45 years of experience as a fashion industry executive and academic in luxury and budget markets. She has consulted on branding, marketing, and licensing strategies for numerous companies and teaches apparel management at the Fashion Institute of Design and Merchandising. Gabriele, thank you for joining us today. I'd like to begin with your background. You're an expert in the fashion, apparel, and textile industry with more than 45 years of experience. Congratulations. Can you explain what an apparel or luxury product authentication expert does?
Well, thank you, Adam, and it's nice to see you today. When you have as many years experience as I have in the apparel industry, hands-on, meaning I owned my own apparel company. I now own my own consulting company. I did sell the apparel company. You get familiar, very familiar with the ins and outs of every category of clothing, and that it would include the designer market, which you refer to as the luxury market. And then you have, of course, the Walmarts of this world, which is the budget or mass market. And then you have Macy's, that type of store, which is a more moderate market. So my experience has been very extensive because when I owned my own company, I was very lucky because I did the expensive category, which is the designer category, in one division. I did the moderately priced category in a totally different named division. And then I did the budget category in a third named division. Owning my own company was a wonderful experience. And as I said, I did sell it. And having worked for myself, it was hard to go to work for someone else. So I then opened a consulting company. And I now work with all three categories on a consulting basis.
In the very beginning, how do you get interested in the fashion industry?
You know, that's a hard thing to answer because I think it's kind of in your blood. It's like I teach at the Fashion Institute. I've been teaching there on a part-time basis for 36 years. And those students, and they're not just high school graduates, I'm in the graduate program. So these are people who've been in the industry. I often ask that question, and the answer is very similar. It's in my blood. I just love clothes. I love fashion. It's just part of who I am. And I've always known that. And that's kind of how my students answer. And it's also how I answered, despite the fact that my graduate degree, I do have a master's, is in economics, but that opened my world to retailing. So I got started because I think I felt I really loved the industry and I've got to get into it.
Well, I'm guessing the fact that you're teaching, you like teaching. And I'm guessing also that you had a lot of teachers along the way in many different forms, and probably the form of mentors. Can you talk a little bit about your path and the mentors that helped you along the way to get you to where you are now?
There's a lot that happens in the apparel industry for which there are no textbooks. And so you either learn it from the hard school of experience, or you are blessed with some mentors. And I had several wonderful mentors. The mentors that I had taught me the areas that I couldn't have learned even by practicing in the industry. For example, I learned all the ins and outs about fabric, how the cotton is spun and how the fibers are actually made from chemicals, and how do we spin the yarn, and how do we make the actual knit product? That was a mentor who actually led me by the hand and showed me that in his own factory. And, that eliminated a lot of years of having to learn it through experience. I learned a lot from experts who worked in the area of inventory management. And in the apparel industry, one of the quickest ways to lose money is if you have too much inventory. So my mentors enabled me to identify and work with the proper levels of inventory at retail or at wholesale, so that in fact you wouldn't have too many markdowns and or finished items that were dated, because in the fashion industry, everything gets dated very quickly. Now, when I have students who want to start their own business, and I happen to teach a class in entrepreneurship, I tend to want to mentor them for the same reason, to kind of cut down on the amount of time they have to invest in learning by doing. And if I mentor them, I can cut that cycle down by telling them how to do it or showing them how to do it. Mentoring is a wonderful thing now that I do it for my students. It's very gratifying. So I'm hoping that the people who are mentors for me feel the same way. I think they do.
I'm guessing from what I know about you, speaking to you days leading up to this, I'm feeling pretty confident about that. So let's talk a little bit about your expert witness work. You touched on a little bit opening your own practice. How did you first get started in the expert work?
Well, a lot of life is being at the right place at the right time. We call that propinquity. FITM, which is the college where I teach, Fashion Institute, had a phone call from an attorney. The attorney said, I need an expert who's familiar with, and he explained what he was looking for. It was a case on licensing. And when I owned my own company, I licensed one of my brands. So FITM called me and said, hey, I've got an attorney. Would you be interested in talking to him to see if you can do what he needs to be done as an expert? That's how I got started. I worked on that case with that attorney. It went to trial, so I got all the experience in one big case. And ever since that time, my husband, who was a marketer, never in the apparel industry, he said to me, you ought to open a practice of expert witness work. This was a great case and you did very well. And, you've overcome the initial hurdles. And that's what I did. And that's how I got started.
Right place at the right time. That's a great start. So let's say, and the fact that you went to trial in your very first case, that's pretty amazing. So during a trial, what's the benefit of involving you early in the case?
Oh, there are lots of benefits. Even if the case doesn't go to trial, but let's say it goes to deposition, or even if it settles, the earlier that the attorney calls me, the more I can help. I can help him as an example with what information will he need, what documentation, the production of documents that would be helpful, not just to me, but also to him or her. The earlier they call me, the easier it is to eliminate the opposition, because I have lots of experience where both attorneys, the attorneys for either side will call me. Both of them call me. Once I've committed to an attorney, I don't uncommit, you see. Also, the earlier that the attorney calls me, especially in federal cases, where I have to write a report, it's called the Federal Rule 26. And there's a lot of commitments to that report. I mean, you have a guideline that's required by the federal courts. And that document must be completely presented to the attorney when he designates me as his expert, you see. Now, if a lawyer calls you a week before he needs to designate, as by the way has happened to me on many occasions, it's very difficult to do that report with, you know, any length and any research, because they all require research. And so it's definitely to their advantage to give me the extra time. I mean, I wrote a report for guests that was 60 pages long, but they gave me a whole month notice, you see. And so there's a very distinct advantage. Now, it doesn't always happen that they give you that time frame.
So strategically, does your early involvement help to the trial attorney, the trial team, help to develop the story and maybe give a little more time for research if more is needed in discovery?
It certainly helps them during discovery, you see. And the way that the lawyers work, they deal with one thing at a time. In other words, when they're designating, they deal with that expert report. And before that, if they have the time, I can tell them, you know, what discovery you should get so that it'll help both of us. It will definitely help. Once you've been designated and you've written the report, then opposing counsel gets a copy of that. And then they decide to depose you. Now, after the deposition, it is extremely common that settlements are reached. In fact, I only go to court about 12 to 15% of my cases. The rest of them settle. Now, if it doesn't settle, now they start with the litigator gets involved and they plan how to go about at trial. And they involve me again with, you know, the storyline and what would go well with the jury and what information they want me to stress and so forth. But you see, trial is limited to whatever I said in my deposition. So a part of that game of what are we going to do at trial has been established.
Right, right. Okay, so let's talk a little bit more about the deposition. Actually, let's talk about anytime you're testifying. So it's at the deposition during discovery, and now we're at trial, so it's trial testimony. The essence of what you're doing is you're educating jurors and probably judges that know nothing about licensing Chanel handbags. You're teaching them. You are the teacher, really. So what's your strategy when you're explaining things like the language that's used in this industry, the ins and the outs, all of those things that are so foreign to the average person?
Remember, because I'm a college professor and I teach in the graduate program, I'm accustomed to the whole teaching method of getting across to my students. And I can tell when they got it, okay? I use the same methodology when I'm talking to a jury. I try not to use the idiomatic language because they won't know what I'm talking about. Fabric, to them, they understand. Piece goods, which is my word for fabric, they wouldn't know what that is. So I use everyday language, and I'm very good about facing the jury and explaining what everything is that is involved in this case. Now, the lawyer should be asking me questions, and the better the questions are, the better I can direct to the jury information. But I've been known to do well when there's a jury trial because I'm so accustomed to teaching. Sure. And I love teaching, which is the only reason I still do it. And therefore, I get very excited, even on the witness stand when I'm talking to the jury, because I want them to really get the essence of what I'm saying.
You've been at this a long time. How do you know if you're truly engaging with the jury in the courtroom? Can you feel that in the moment? And do you maybe change a little bit of your strategy when you're there on the witness stand testifying?
I've learned to read body language about when they get it or they don't get it. You can see on their face, they squint a little bit, they didn't get it. And so I immediately go down and try again on a lower level to get there. I never want to talk down to a jury, but there are times, maybe because, this whole thing is in my blood. I mean, I live the fashion industry, and maybe I went a little bit into too much detail, or maybe they just didn't get it. I can tell from their faces and their body language. And I can tell when they have that aha moment, and that's very gratifying.
So I'm curious to know, you said you have a very small amount of cases that actually go to trial, and that's not surprising. We all know that a lot of cases settle. When you're in those teaching moments, can you talk a little bit about any sorts of visual aids you've used along the way when explaining complicated concepts, or maybe some of the language and the terms that you've talked about?
Okay, I'll be happy to do that. Now, let's go back a minute to that expert report. In that expert report, I must divulge all my opinions, and I must divulge all of my research, because I can't just say it's my opinion that. I have to support that with, underlying documents. Now, those documents, I always use a lot of exhibits. So if I'm doing, a copyright case that has a print on fabric that somebody else is being allegedly to have infringed upon, then I will make exhibits for that report to show whether they did or didn't. Okay, now those exhibits go with me to trial, so that not just the lawyers could see it, they use that document to depose me, but now those exhibits, I will enlarge them and post them up for the jury to see it. That's very, very effective for a jury. Visual exhibits are much, much better than words. But so if I put up a visual exhibit, then I can use words to address that exhibit. So I make a lot of exhibits for that reason.
Yeah. Do you ever have any cases, like I have daughters, so I keep talking about the purses examples, but do you ever have cases where you bring in a physical object? And I'm curious to know, what's your perception of, you've got electronic exhibits that you're showing on a screen, but you also occasionally might have something you show in your hand or hand to the jury. Does that ever come up in your cases?
Well, when we go to trial, the expert and the attorney, the litigator attorney, we work closely together. In other words, I bring to trial those components that the attorney feels would be most beneficial. So if I'm doing a handbag case, and, like Gucci and Guess sued each other, and the handbags were involved, the same thing with Coach, I've done all those handbags. If they want me to bring the original and the alleged one that is threatening to be, a conflict, if they ask that, then I bring the actual items. But I usually just show large visual exhibits on a screen. They're just as effective, I think, as bringing the live item.
Yeah. Okay, so a little while ago, you talked about, I can't remember, I think it was a case with Guess, and you said the expert report was something like 60 pages long. Yeah. I'm curious to know, how do you keep track of that? So you've created this document, this report, you've been deposed about it. What is your strategy for making sure you know every bit of that when you go to trial and you're going to be crossed on that report? Talk a little bit about that strategy.
I'll tell you a giveaway. When you're sitting on the witness stand, there's a book on the ledge there, and that book has your report. So at any time that I want to, I'm allowed to go to that book and look at my report, and I can say, Well, if you recall, when the attorney is talking to me on page 17, I went into detail extensively about this, and that, and the other. So because they use my deposition as the source for questioning me, I also am allowed as well to use my own deposition. So they do allow you a copy. It's sitting there. So I'm allowed to refer to it. And, writing an expert report, I write, and then I edit, and then I write, and I edit. And I mean, it takes a long time. So by the time I finish, I probably know that report inside and out. And, when I said 60 pages, remember, in my report, I also have a lot of visuals in my report. Partly because I want to use them if I'm going to trial too, then I'm allowed to show them, you see.
Sure.
I can't bring anything that I haven't referred to in my depo.
Yeah. But are you reading up and catching up on it if you haven't looked at it in 2 years, that maybe the week before trial, are you going back to look at it at all?
No, the life of an expert witness before it goes to trial is very busy. Why? Because there's what's called depo prep or trial prep. So you meet with the attorneys if they want to, and most often they do, and they have a session where they do trial preparation. And the same thing with a deposition. They do that ahead of time, the day before or 2 days before. Now, that doesn't end there. I still do my own, prep. That means I review everything. I review everything in my deposition. I review all my exhibits. I review anything and everything, any opinions that I've given or anything that I feel in my gut, they're going to ask me about. I do that on my own. So I'm prepared.
So we're still talking about being on the stand. And I'm curious to know, without being led by an attorney, how important is it for an attorney to guide their expert witnesses?
My own attorney, by asking the right question, lays the foundation to our case. So the attorney that's his job, a litigator. He or she, and then sometimes even during prep, they tell me, I'm going to ask you a lot about this. I'm going to ask you a lot about that. And that's invaluable to me. And that's why I sit on the witness stand and I'm not nervous. I mean, I'm not bragging, but the reason I'm not nervous is because I did my homework.
Sure.
And I know what I'm talking about. So, and my attorneys have also prepped me. So that helps a lot.
So that's direct. Now let's switch over to cross. What is the strategy when it comes to cross-examination, how you prepare for that?
I learned way back, like I said, I've been doing this for 26 years. You answer yes, no, or I don't recall. If it's a case of where they ask you a direct question, don't give any more details than you're asked. Just say, yes, that's correct, or no, that's not correct, or I don't remember. I prepare with my own attorney as to, my first question when it goes to trial of my own attorney is, okay, where am I vulnerable? Where are they going to attack me? And they usually will clue me in. Now, if I was grilling you, this is where I would go. So, I'm okay with that. And they're helping me and they're prepping me and they're showing me where I'm vulnerable. I do the same thing before a deposition. I say, okay, where am I vulnerable? I mean, I really know this stuff, now where are they going to get me? And if there is an area where they think, they will tell me. Good attorneys work with their experts, and it pays off for both the expert and the attorney.
Okay, so let's switch gears a little bit. Let's talk about the industry and the types of cases. So what are some common legal disputes that develop in the industry, and maybe what sort of cases result from those disputes?
Well, there are lots, but I'll give you a few. There's trademark infringement. Your trademark is your brand identifier. So you don't want anybody else to use it. And then there's copyright infringement, which is intellectual, is what you own what you created. So but in addition to, the intellectual property cases, I've done a lot of cases that relate to issues of quality. You have your goods made in China and they come here and there's a big problem with quality. It's a lawsuit. There's a lot of cases have to do with licensing. I let you use my license, but you destroyed my license because you sold it at a level that I don't want my brand exposed. I'm a better brand and you sold it to Costco. So there's a lawsuit in licensing. Then there is, besides quality control, I've done a lot of cases, not so much now currently, but in the past, where employees sue, it's usually class action, their employer. What do they sue for? The employer says you must wear either certain colors, or you must wear my clothes, whatever I'm selling in the store, and you must wear those clothes in excellent condition. That was the case with Tommy Bahama, who the employees had to wear some of the silk tops, and silk is very hard unless you dry clean it. It's hard to get it to look like it was when it was new. I've done several cases that have to do with product development processes. Okay, I had a wonderful case where a contractor developed the jeans to fit perfectly for the particular label. The contractor didn't charge for those. They're called patterns. You need to make a set of patterns. You draw them by hand or you can do them on the computer. And that's the outline of how the garment eventually is going to fit, because you use those pieces, you put them together and the garment will fit. Now, this particular brand had tried everything. They tried hiring their own people. They tried using freelancers. And then this contractor said, don't worry, I know how to do it. And if I do it and you are satisfied, then I want all your production. I won't charge you for the patterns, which is a very expensive proposition. There was a lawsuit. Why? Because after 7 years of working with this contractor who made the jeans fit right, and thousands of them were sold, I mean, hundreds of thousands, the brand said, you know what, I'm going to go to China. It's cheaper. And then the contractor said, that's not a problem. The brand said, I'd like to get my patterns. Contractor said, you can't get those patterns unless you pay me. Why? They're my intellectual property. I own the rights to those patterns. I created them. And I never transferred ownership. I did all your production, but I never gave you ownership. That was a big case. And by the way, the contractor won. That went to trial. I sat on the witness stand for about 2-3 hours explaining what patterns are and how this whole process. And patterns are part of the development of a product, how to get it to fit right.
So you made me think of patterns, and I don't know why, but Burberry's came to mind. It's a very specific look. So let's talk, I want you to give us another hypothetical. Let's say a designer at Burberry's comes up with an amazing idea for some new product. Could be shirt, tie, anything. How does the process of manufacturing that go from coming up with the idea to selling it in stores?
Okay, well, the product developer comes up with the idea. And generally, having owned my own company, I know how we did it, and that's how I know from my consulting practice too. After the product developer comes up with the idea, they present it to a committee, which is usually your management, your merchandiser, your production people. to make sure that the fabric is right, production can work with that fabric, that the pricing, the estimated cost to make it is right, that the product potential price is within the target market of where you're selling. And once all of that is approved, yes, it's priced right, the styling is right for my target customer, okay. The product development people have selected the fabric and have selected the styling. Now production goes in, and they will try and make samples for salesmen. The salesmen use the samples to show buyers. Buyers place orders, and the orders are then filled through the production department, who usually outsources the production, the cut and sew. And after that's done, it's shipped to the store with all the requirements that the buyer put on the purchase order. That process, when I first started, and I first owned my own company, used to take anywhere from 3 to 6 months. Now you can do it in 2 weeks.
So based on that scenario that you just gave, the Burberry product going, from conception of the idea to the store, why don't you give us an example of an intellectual property dispute that might come up in that sort of scenario?
What's very common in product development in this discussion that we just had is the designer wants to use a print, a fabric with a print on it. Okay. Now, whoever is the originator of that print, if they applied for copyrights, meaning they own the right to that particular print, that designer has to be sure that she is released, and nobody can come back and say, hey, you're using my print, I own it, so you are infringing on my private ownership. And there are a lot of copyright cases, an awful lot, in that particular area. Now, even Burberry is known for a very special striping kind of a print that they use. Like, have you ever seen the inside lining of a Burberry raincoat? Okay, well, they own the rights to that. It's like their trademark, but it's also probably copyrighted. So anybody who wants to use something like that better make sure that they're not using exactly what Burberry is using, because Burberry owns that through a copyright registration in Washington, D.C. We have a lot of copyrights about prints, and I've probably done 50 or more cases of that, where during product development, you're using a Navajo print. I did that case where the Navajo sued manufacturers for that Navajo looking print. They said, we own the rights to that. You are infringing on our intellectual property. And either you cease and desist and stop using that particular print, or you can fight it by saying it's not the same print. There's no visible similarity if you can prove that. When I do consulting with clients and I see that they're using certain prints, I tell them sometimes it's better. I give you an example. I have a client who makes dresses, and she had a dress on her line that looked just like that Marilyn Monroe dress that kind of went up in the air when the subway air blew on it. And she called that dress the Marilyn Monroe dress. And I said to her, you will get a lawsuit because the Marilyn Monroe estate owns the right to that look. I mean, that name of that dress, the Marilyn Monroe dress. I recommend you make the dress, but give it another name, anything else. So that would be a perfect example, you see. And she did, because it's not worth fighting it. Fighting a copyright case or a trademark case or a licensing case, very, very expensive. So, and that's very common during the product development cycle when they're selecting their prints.
So let's talk a little bit about trademark cases. We've got consumer confusion, value deflation caused by maybe a designer and a company using the same name or the same logo. Why don't you give us some examples of those sorts of scenarios?
All right. Well, a trademark is either a name or a slogan, or it's an identifier for your brand. And if you've trademarked that with the trademark office in Washington, D.C., you have to make sure that nobody else is using it. Why? Because if anybody else uses it, it dilutes the strength of your brand. Your identifier is what builds customer loyalty. It's what builds what we call customer equity, because it tends to have the customer reorder over and over again. They make associations with your brand. That's why a trademark is very valuable. The case of Gucci and Guess is a perfect example. Gucci's trademark is the GG, the double G, in various different forms. But Guess can't help it that their name starts with a G. Guess House uses the double G. I don't have to tell you that they fought each other. Now, the big question is it causing consumer confusion? And if it does, then you have brand dilution. And the argument of Guess was, it does not cause consumer confusion because a Gucci handbag can be $5,000, but a Guess handbag can be $49.95. And Guess does use the double G, but in a totally different format than what Gucci is using. So there's all kinds of arguments going back and forth. That one was, the trial took a whole week in New York. And I don't believe that Gucci got much.
So let's talk a little bit, this makes me think of, we've heard counterfeits, we've heard knockoffs. What are the differences between those two, and how is that policed?
Oh, well, counterfeits are illegal. And theoretically, and I say theoretically because sometimes they just don't have enough people down at the docks and stuff, but customs checks your goods as they come in to see that they are either counterfeit or that they are, the brand that it says. A counterfeit is if you make a garment or a purse or a pair of shoes and you call it the name of the brand who makes it. So if, let's say, a handbag, you made a handbag, it's an exact copy of a Prada bag, and you call it a Prada bag. Well, that's a counterfeit because it's not a Prada bag. Now, you can make the Prada bag because there's no protection for a style. Okay, a style is the silhouette of, let's say, a handbag or a garment. You can make that Prada bag or a bag looking like Prada and call it the Gabriele, which is my name, and call it the Gabriele bag. And all you've done is created a knockoff, which is an exact copy of somebody's product. That's allowed. Customs monitors and checks for counterfeits. And there's a new job description. There are people who are employed by brands to do nothing but go to the retailers and see if there's any counterfeits hanging. If you recall, eBay several years ago, unfortunately, because they didn't know any better, was selling counterfeits. And that was a big problem. And so eBay now, whenever they get merchandise to sell through there, they have to have it validated as, a true item.
Mm-hmm. How does a company or a designer prove original intellectual property and ownership?
Intellectual property, you're talking now about copyrights like prints. Well, you apply for a copyright registration. And on that copyright, that document, you have to say, who the author is. Now, you can say, I own this print, but I bought the print from this art design studio. That's allowed, because when you bought it, they gave you an invoice and you paid the invoice, so ownership was transferred to you. Now you can register it with the Copyright Bureau in Washington. The same thing is true of a trademark. That's you have to do the same thing. You have to submit proof that this is your identifier, and that you've used it, for the past so many years, and now you want to trademark it.
Well, thank you. All of that's been very insightful. Let's talk a little bit about trends. Do you see any kind of emerging trends in the fashion industry coming now or in the next few years?
Definitely. There are several trends. One of them is that a brand now, unlike in the past, has to have what we call multiple channels of distribution. A channel of distribution is how you sell. It used to be if you sold in the retail world, if you made a garment and then Nordstrom's bought it from you, that was fine. Not anymore. Now you have to have, yes, you want to have, you sell to the retailer to sell your items, all right? That's one channel. Now you also have a website and you can sell direct to consumer. That's the second channel. The third channel is what we call a third party. That's Amazon or eBay or any of the others. And many brands now are in the resale business. In other words, like if you send Patagonia an item back that you bought from them, they will recycle it and they can resell it, and they will give you a certain amount of money for it, which you can use to buy their product or whatever. All those channels are very valid today. The whole issue of recycling clothes, buying secondhand clothes, that was old fashioned. Barbara Streisand did it when she was a young girl and made some music to describe that, but it was not big time done. Now, especially among the young people, very big. So there's your fourth channel of distribution. That's the trend. That the next and last trend that I need to address is the current dominance. I say current because I think over a period of years, some of these trends will go away and new trends will come about. But right now, the social media channels, whichever one you want to go to, is another channel of distribution, which never was big before. The influencers that talk on Instagram and wear a certain outfit, you can now push a button and buy it. So that's all new and very much in. Now, there's other trends, which is we never really shopped online the way we do now. That's directly an outcome of the pandemic, but it will continue. Last, technology. The garment industry was really the last industry that really used and developed technology to expedite and make things happen quicker. It's now so unbelievably data-driven, consumer-driven. Everything can be done online now. You create your whole line online on the computer. You don't have to sketch, nothing.
Well, it seems like a lot of things changed in how we buy things based on the pandemic. So those are great examples. So if we looked 5 to 10 years in the future related to those trends, what do you think the kind of the corresponding legal disputes will be around those things?
I have had already disputes, for example, where a wholesaler sold it to a reseller, and the retailer claimed it was faulty goods. The wholesaler didn't want to take it back, or the wholesaler said, it's too old, I can't take it back. If it was really faulty, you should have let me know immediately. There's lawsuits over that. Inventory is a big issue. And I did a big case there where one of the retailers, to make sure that if business was good, they had enough inventory at all times, they wrote what we call backup orders. to the manufacturer. Now, theoretically, that said to the manufacturer, you better have these goods on hand for when I need them. Now, that same retailer, in this case, went at the last minute and canceled his backup orders, and the manufacturer is stuck with them. Big case. Okay. Over that issue. And so there's now all kinds of online capabilities to avoid that. Now, Walmart, Target, many of the big retailers who buy large quantities, they're tied into the manufacturer directly. So every time they make a sale, it reduces their inventory. And the manufacturer sees that. And the manufacturer has been told what their reorder point is. And when that retailer hits their reorder point, unless they have a different agreement, the manufacturer automatically has the right to make them and ship them. So, you know, we have a lot of these new technologies that direct access of how you're going about in sales.
So what advice would you give somebody who is new to being an expert or is wanting to become an expert witness?
Well, I would advise them that before you even think about doing expert witnesses, you better be extremely familiar with every phase of the work that is needed and done in the apparel industry. So if you want to go in and be an expert in the apparel industry, don't go there until you've either done all of those phases, which by the way, I have, and or you are extremely familiar with every part of the apparel industry, because when you are asked to be an expert, you really have to be an expert, not just somebody who's familiar, but somebody who's really a pro. So don't even apply until you feel you have that experience. Now you got to remember, although I've been doing it for 26 years, I have more than 45. I have closer to 55 years in the apparel industry. So I have legitimate experience, and the United States government has already used me as an apparel expert in, you know, the USAID, which is an agency for underdeveloped countries where they can ask for experts. And they've sent me all over the world as an apparel expert. So I have the credentials, plus I have the valid background. I've done all of it. Every phase, I've done production, I've done product development, I've done it all. Because not only through owning my own company, but you know, somewhere I had to start. And I had good mentors, I learned, and I was determined, and I did it all. So my recommendation is don't go until you have valid experience and valid knowledge.
All right, so very last question for you, and it's one on mental health. How do you balance your consulting work, your work as an expert witness, while still having personal time for yourself, your family, and your friends?
That's an excellent question because it's a big issue. I'm very good with my attorneys in telling them about my own deadlines. And so when they ask me to do something, I have one case where they gave me 3 days. I just don't take it because my mental health would be suffering. I would be too stressed out. You know, I pushed very hard to get all my documents from the attorneys early enough so that I can do it on my schedule. And I have every attorney I work with, when they need dates, like for deposition, I pick the date. I tell them I can do it this day, and this day. And they have to pick one of those days, you see. So I'm very careful about scheduling. I've learned that now over the years because I did have 3 children and raised them. And I'm careful always to schedule everything so that I can manage. It's important. Everybody has to do that.
Well, it sounds like you're juggling a lot and you're juggling it successfully. Thank you, Gabriele, for your time. We really appreciate it.
You're most welcome. I enjoyed it.
Thank you to Gabriele Goldaper for speaking with us today, and a special thanks to our listeners. At IMS, we're trusted to deliver consulting services to the most influential global law firms, early with pre-suit and investigation services, then in litigation during discovery, arbitration, and trial. It's been our privilege to serve our clients on more than 20,000 cases and over 2,000 trials. Be sure to subscribe to our podcast and join us next time on the IMS Insights podcast.